former director of the Ghana School of Law, on his thoughts on some of these allegations that we have been seeing, and the allegations which form the basis of the prima facie case against him, for which reason the Honorable Chief Justice is being suspended. Hello, good evening, sir. Welcome to Eyewitness News.
Good evening. Thank you for having me on the show.
Yes, we have snippets of some of the allegations made by the three petitioners, key amongst them being Mr. Daniel Ofori, who is a known investor and has been quite popular around the courts, when it comes to commercial matters. Have you had the opportunity of looking at some of the allegations yourself?
Against the Chief Justice?
That is so.
No, not yet.
Okay, so there are. So let me just take you through a few of those allegations, and so we see whether these are strong enough or enough to ground a prima facie case against the Honorable Chief Justice. So the first one, in respect of Daniel Ofori's petition, says that in 2023, the Chief Justice misappropriated a sum of 261,890 cedis of public funds for the benefit of the Chief Justice for her private foreign travel with her husband, Mr. Francis Kofi Torkornoo, and her daughter, Miss Edem Torkornoo, and $30,000 in per diem allowance when, to her knowledge, neither the husband of the Chief Justice nor the Chief Justice's daughter were entitled to have their travel or any travel allowances paid out of the funds of the Judicial service. So the Chief Justice also responds to this and says that, so this is her response, that the petitioner alleges that as Chief Justice, I misappropriated the sum of 261,890 cedis of public funds for my private travel, foreign travel with my husband and daughter, when according to him, neither person was entitled to have their travel paid for out of the funds of the Judicial Service of Ghana. So my humble response is that the allegation is an unfortunate untruth. So she attaches some evidence to this, and she further says that she attached some exhibits. We do not have the exhibit, so we can only read what it is. It said exhibit DO2 is a policy on foreign travels by head of the judiciary and then superior court judges. Paragraph A9 provides that the Chief Justice shall undertake unlimited official travels with either his or her spouse or other person of his or her choice in a year, fully funded by the Judicial Service. Paragraph A10 provides that where the Chief Justice is accompanied by the spouse or other person, he or she shall travel on the same class of air ticket as the Chief Justice and shall be paid the equivalent of half of the per diem paid to the Chief Justice. She says this has been the policy of the Judicial Service since 2010 as amended in 2019. So see Exhibit DO3. So an Exhibit DO4 is a response to audit observation provided by the Judicial Secretary to auditors who sought clarification on the expenditure on the ticket purchased for my husband and daughter during my 2 holidays in 2023. On page 1 of Exhibit DO4, the Judicial Secretary clarified that as Chief Justice, I opted to utilize the authorization in paragraph 9 and paragraph 10 of the travel policy to travel with my spouse and my daughter during my 2 holidays taken in September 2023, pursuant to the conditions of appointment of the Chief Justice. In view of this option, there was no infraction occasioned when I opted to travel for my 2 holidays with my spouse on 1 occasion and my daughter on the 2nd occasion. The response to observation 1 and response to observation 2 of Exhibit DO4 provide explanation on expenditure on tickets for my husband and daughter that the petitioner has unfortunately described as misappropriation of public funds by the CJ. She goes on and on to say that response to page 3 of Exhibit DO4 further confirms that contrary to the unfortunate allegation that I failed to retire 14,000 given to me for my travel, I spent an amount of 4,411 out of the said interest and retired the remaining $9,588 dollars I also attach here with Exhibit DO5 in further proof of that. So there were also specific allegations around her conduct as CJ in terms of.
Hello?
Can you hear me?
Yes.
So there were other allegations in respect of how she allegedly interfered with cases. So there was one on the Republic versus Judicial, where the petitioner says that the Honorable Chief Justice, without the knowledge of the accused person and his lawyer, unconstitutionally interfered with judicial proceedings in the case of Republic versus Judicial in the High Court, Criminal Division 3, by accusing the arrest and more by causing, I think, the arrest and maltreatment at the offices of the National Security of the Judicial Service Personnel of the ICT Division of the Law Courts Complex and the Judicial Service Personnel of the High Court, Criminal Division 3, as well as the questioning of the said officials of the Judicial Service by the officials of the National Security that the Honorable Chief Justice had caused to go to the High Court, Criminal Division 3. It continues to say that the Honorable Chief Justice falsely and maliciously accused two members of staff of the Judicial Service, namely Francis Badin and Adjoa Boatema Prempe, of tampering with the record of the proceedings for 19th July 2023 in the case of Republic versus Judicial, and set up a committee of inquiry, also without the knowledge or involvement of the accused person and his lawyer, even though the proceedings alleged to have been tampered with related to proceedings in the case and were of interest to the accused persons. It goes on to say, under allegation 7, that the Honorable Chief Justice arbitrarily, capriciously, and unreasonably and maliciously transferred Francis Badin, Deputy ICT Director of the Judicial Service, from the said position to the Regional Administration Judicial Service Tamale to coordinate activities of private process service in the northern, northeast, Savannah, Upper East and Upper West regions of the country, immediately upon Francis Badin being exonerated by a committee of inquiry set up by the Chief Justice and reinstated to his position as Deputy ICT Director, as recommended by the committee, from the false charge of tampering with the evidence. It goes on to say that the Honorable Chief Justice, in bad faith and arbitrarily and unreasonably, transferred the execution proceedings initiated on the directions of the Supreme Court. Okay, so that's in respect of a different matter. So in terms of allegation 7 and 8, which relates to the tampering of evidence, the Chief Justice's response is that these allegations that as Chief Justice are interfered with judicial proceedings in the case of Republic versus Judicial in the Criminal Division 3 nothing can be further from the truth. It says that on July 28, 2023, I received an unusual report. And so there's Exhibit DO6, I'm sure, which is a report that she received, that the judge in charge of Criminal Division 3 had lost digitally created records of proceedings in the said case. I immediately went with the Judicial Secretary and Director of ICT to the court to understand the issue and found that the problem was even more bizarre. The court's records were reported to have been digitally changed. She says, after listening to the judge, I met with all ICT staff in the auditorium and addressed them on the unfortunate situation that had happened and sought their assistance in resolving the problem. Thereafter, I directed an investigation to be conducted into the incident. DO6A is a report from the National Signals Bureau, the national institution with the capability to investigate the nature of the incident. And it goes on and on to say that the final report appointed by the Judicial Service to investigate, so that final report was attached. So in the 4 to 6 allegations, the petitioner repeatedly complains that as Chief Justice, I was personally involved in the resolution of the incident and conducted myself unconstitutionally by not involving the accused person and his lawyers in the resolution of the incident involving court proceedings. That is an unfortunate misconception. So as head of the Judiciary and Judicial Service, I had no duty to interact with a lawyer of the accused person whose records had been changed within the court's computers. Further, apart from the first day when I went to the court in the law court complex on receipt of the report, I left all other processes to relevant officers. I had no personal contact with the staff named in all these reports. It goes on and on. So far, from what you have heard, what will be your reaction or your response.
Okay, thank you very much. My response is a very simple and straightforward one. These are the very matters for the current consideration of the committee that His Excellency the President has set up. Therefore, I would not want to make any comments, that because the matter, is of judice pending before a committee duly established pursuant to Article 146 of the Constitution. The only comment I wish to make is that the first one, which is traveling with spouse and daughter and whatever, these are, matters arising from, contract of employment. So there are issues that, can be gleaned from the terms and conditions of appointment. If she was entitled, to do, she did not, as it were, formulate the terms and conditions, by herself. It was the Judicial Council or, whoever appointed her. So, as far as I'm concerned, I don't see anything wrong, with an office holder enjoying, the, terms and conditions of appointment. So that's the comment I'll make. The other comment, let the committee that is seized, of the matter go into the merit and make their findings. I don't want to prejudice. Any comment, will not order well, for it to be interfering, what the president seeks to do.
I see. No, I perfectly understand that. We understand that 2 more petitions have been filed and same have been sent to the CJ for her response. What effect will these 2 petitions have? The lady is already on suspension. What will be the effect of these 2 petitions then?
What they are trying to suggest is that, if a person has been accused of something in standing trial and there's a fresh, allegation of criminality because of the pending one, these are fresh matters. And therefore, the president, will be constitutionally, right in following same due process. The fact that, petitions are pending, doesn't prevent the president from acting constitutionally. I think even if there are 1 million petitions, let him forward, the petitions in accordance with the mechanisms established in the Constitution.
I see.
What I see, of all this is that it appears that some people have vowed, to unseat the chief justice. It's unfortunate. It's rather unfortunate that in all these matters, we have singled out, one of the institutions of governance for, humiliation and mockery. What we are doing now, we are tarnishing the image of the Ghana judiciary. We think that it is just get to Torkornoo today, and therefore, an NDC government can do whatever, it desires to do in order, to cross an exit. But at the same time, it is the image of the country. It's sinking low, and maybe we have to do something about that. The president is acting in accordance with the Constitution. I would suggest that any more petitions, should be handled with care and circumspection. I think that the presidency should try to act quiet, on the quiet. Let's send this and deal with them as if nothing has happened. We already have 5. So 3 plus 2, 5. Many more will come. Please, Mr. President, make sure that there isn't any more disclosure about them. Just send it to the Council of State. Let them also be discreet about, the new and newer petitions, that are in the offing and will come. Just be discreet about them. Send them to the Council of State. No more, public disclosures, and let the committee work. And then one day the committee, will just present their findings and the verdict, and the president will let the nation know, the verdict that has been arrived at. But many more petitions is like now, castigating, assassinating the character of the Chief Justice, humiliating her, vilifying her, and all these things. It is not the person or personality of Torkornoo. It is the high office of Chief Justice of Ghana. So enough is enough. The comedy is, enough now. All of us, are laughing one way or the other. Mr. President, put an end to this saga. Let the committee work, on the quiet. After all, the committee's proceedings are in camera. So enough of the publicity. Let us try to protect the image of the office of Chief Justice. We have an acting Chief Justice now. Let the acting Chief Justice, go about his duties without any, fear. The way we are going about this, I think we are getting on the nerves of the nation.
I see. Is a point you're making that if new petitions come, the public shouldn't be made aware. Of course, and the public shouldn't be made aware. The president should just go ahead.
There's nowhere has it been written in the Constitution that when petitions come, the president, must make the petitions a public matter, so that it becomes a public document that is, everybody's, knowledge and public domain and all that. The Constitution says that the president shall forward the petition to the Council of State and shall act about meeting, the Council of State, whether a permanent is, has been established or not. The Constitution is not saying that each time there's a petition, the president should give it to public agenda, to evening news, to daily guide, graphic, to Ansa-Asare, to Citi, news, to this and that. No. That's not what the Constitution, contemplated. The Constitution contemplated some respectability in this affair, so that if it comes, we have discussed this, enough, and I think that any more petitions should just find their way to the Council of State, and otherwise we are watching too many dirty lines in the public, and our neighbors are laughing at us.
So kindly help us understand how it works. So these two new petitions, does it mean that this will also have to go through a process of its own, or because there's already an ongoing process, we can just add this to what the committee is doing, and the committee will deal with?
You shouldn't just forward them. You should follow, the provisions enshrined, in Article 146. Follow it to the letter. But in so doing, you should be devoid of, this public entertainment. Is the entertainment aspect that I'm trying.
So it's possible we'll have multiple committees working on a determination.
I won't be surprised if by Friday we have our 20 more.
So if it happens, then it means that we may have multiple committees sitting to assess.
So one committee is enough. The president shall set up. If you read it literally, then what you are saying may be true. That's at first glance, it means each time. But the Constitution did not anticipate this sort of thing happening, and therefore, since we are developing a jurisprudence around the removal process of the Chief Justice, what do? We have a committee. Any new petition could go through the same mail and then end up with the same committee to save expenditure. If we have to set up committees per the number of petitions. If there are 1,000 petitions, it means we'll have 1,000 committees. I mean, the whole nation will come to a wall.
Yeah, so I asked because you said we should allow the petitions to go through the process. So yes, I can appreciate that it has to go to the Council of State.
One committee should be enough. By sheer common sense, yes, one petition should be committee should be enough. You say, first of all, mind you, say the president shall set up a committee of 5, comprising 2 justices of the Supreme Court, then 3 other members. When we have 20, we would have exhausted the
number of justices on the Supreme Court.
Yes. Therefore, what it means is that by sheer and good reasoning, we have one committee. We will have the 2 justices of the Supreme Court. We will have the 3 people who have been, give them the work to do. Expediency should be the hallmark of the whole thing. And therefore, if we have, say, 10, 20, 15 petitions, since we want, to bring this matter to an end soonest, that committee should be charged or tasked to work day and night and ensure that they can, make their verdict known to the president, who will then, take the final decision upon the advice of the Judicial of the Council of State. So I don't think multiplicity, of petitions, should ensure the establishment of multiple committees.
Very well.
That is not, a reasonable thing to construe after the provision. One committee is sufficient.
Thank you so much, Kwaku Ansa-Asare, private legal practitioner, former director of the Ghana School of Law. Thanks so much for speaking to us.